Hi friends, it is said that laws are evolved. Yes, every time we see the law, we get confused, we put a case, we argue, and then we come to a conclusion with a judgment that how exactly that needs to be understood, and then there will be interpretations followed. Now, I am sure from 28th February 2019, if not everybody, at least among the HR fraternity, the most discussed topic is the Supreme Court judgment on basic wages meaning under PF Act. So this is the session to understand what is basic wages under PF Act as per the new judgment given by Supreme Court on 28th February 2019. This session will have a lot of readings. I have put a lot of pictures from the judgment given by the Supreme Court. So I have not taken time to type everything because almost all of them are being typed by the Supreme Court. So I am taking you through them. Let's go to page number 1. So the pretext, one question that what is basic wages under PF Act. Then there were 5 cases which took 6 to 8 years by Supreme Court. Then one major reference was being taken by the court, and then they have given a judgment with 21 pages. Then that one para attempt to answer the big question, is that the answer or is it bringing too many questions? Let's go through the presentation and try to understand what exactly happened with these 5 cases, what are those references, and finally what is the meaning of basic wages, do we know or not? Let's see the presentation. Now, what is basic wages as per PF Act? Section 2B, like every act, will define the major components of the acts is being defined in usually section 2. Now, in section 2 of PF Act, 2B covers the definition on basic wages. I will read through. Basic wages means all emoluments which are earned by an employee while on duty or on leave or on holidays, with wages in either case in accordance with the terms of the contract of employment, and which are paid or payable in cash to him, but does not include. Now the first portion is telling what does it include, and the second portion they continue with what it does not include. The cash value of any food concession, any dearness allowance, friends, see this point, that is to say all cash payments by whatever name called paid to an employee on account of a rise in the cost of living. That's the first part, that is on DA. Then they continue, house rent allowance is not considered, overtime allowance will not be considered, bonus will not be considered, commission or any other similar allowances payable to the employee in respect of his employment or of work done in such employment are excluded. Any present made by the employer. So they have made 3 major subsection under 2B on which are not covered. The first one is the cash value of any food concession, second one on DA, and then they continued with HRA, overtime, bonus, commission, and any other similar allowances payable, and finally any present made by the employer is an exception for basic wages. Now I told you when I was telling about dearness allowance to observe it. I requested you to do so because that was a mistake done in section 2B. However, the act corrected itself in the section 6 of the act. Now let us see what does section 6 says. Section 6 rates contribution and matters which may be provided for in schemes. The contribution which shall be paid by the employee to the fund shall be 10% of the basic wage, dearness allowance and retaining allowance. Now you have 3 components here. The first one being basic wages, which has been already covered in 2B. Then they are covering dearness allowance, which was excluded in 2B2, but then they brought in here. And then retaining allowance. Retaining allowance are the allowances which are given in the seasonal industries like sugar industry, which runs seasonally. To retain their employee, they will keep giving some allowance which is called retaining allowance. and that is being covered under basic wages definition of PF Act. Now in the first stanza it was given 10%, but the contribution is revised to 12%, which is covered in the second stanza. You can read through it, pause the video and read the entire session. I will not spend all the time because there might be people who are aware of this, so I don't want to do repetition of that. So for the benefit of majority, I am continuing to the next slide. There are two major observations you have to see. That is explanation 1. For the purpose of this section, dearness allowance shall be deemed to include also the cash value of any food concession allowed to the employee. This needs to be considered. And explanation 2 says, for the purpose of this section, retaining allowance means allowance payable for the time being to an employee or any factory or other establishments during any period in which the establishment is not working, for retaining his services. Yeah, my guest is here.
Hey guys, subscribe my father's channel.
Subscribe my channel for more videos on recent updates on law and legal classes. Now continuing, I hope you understood that DA part is been covered by section 6, and then they further covered the retaining allowance part in section 6. So now that we have understood that basic plus DA plus retaining allowance are basic wages as per PF Act. At least we thought that is basic wages all these years. Now continuing on a summary, my summary on these two sections, what is covered under basic wages and what are not considered under basic wages as per the definition of PF Act that all this year we thought. Now basic wages means all emoluments which are earned by an employee while on duty or on leave or on holiday with wages, in either case in accordance with the terms of contract of employment, and which are paid or payable in cash to him. DA was considered under exception in 2.2 but later corrected in section 6, and the retaining allowance section 6 explanation 2. These are the three components which are covered under basic wages. What are excluded? The cash value of food concession. Any dearness allowances which was excluded earlier in 2B, I have made it green because now it is been covered after the section 6, not now, from the beginning, after section 6 which clarifies. Then there are exceptions on house rent allowance, overtime allowance, bonus, commission or any other similar allowance payable to the employee in respect of his work done in such employment, and any present made by the employer. So we know what is covered and what is not covered. Moving on, there is one landmark case we have to understand before we try understand anything of this recent judgment. There was a judgment given in the year 1963 for the Bridge and Roof Company case. I'll just read through the important points taken from Bridge and Roof, or the references. When I said in the second slide one important judgment, this is the judgment I was referring. So let us try understand what did they say in Bridge and Roof judgment. Whatever is payable by all concerns or earned by all permanent employee had to be included in basic wages. Now if you see it, there is quite a lot of technical aspects involved here. Whatever is payable by all concerns are earned. So the component that we are discussing should be paid to all the concerned permanent employees, and such allowances need to be considered in basic wages. That's the first part. Second one, only such allowances not payable by all concerns or may not be earned by all employees of the concern, that would stand excluded from deduction. Now whatever you are paying to all the employees of your company is covered under basic wages, and whatever you are not paying to all your employees in your organization is excluded from this basic part. It is only when worker produces beyond the base standard, what he earns would not be a basic wage but a production bonus or incentive wage which would fall outside the purview of basic wages under section 2b of the act. Now, under a normal circumstances, on a regular monthly working, if a employee is getting salary on particular allowance, then that is basic wages, and whatever he is earning through additional effort like overtime by staying extra or production incentive by achieving production targets, all those stuffs are not covered under PF basic wages. This was concluded in Bridge and Roof Company. This is referred very strongly in the current judgment. Before going to the 5 cases, let's understand few other cases which are very interesting and very much connected to this judgment. One among them is Manipal Academy of Higher Education case. Now see the title of this slide, universally, ordinarily, necessarily. This is the famous term used by Bridge and Roof case. Now universally, ordinarily, necessarily, you can remember as UNO, universally, necessarily and ordinarily, but that is not in sequence as per the judgment. So I have kept as sequence universally, ordinarily, necessarily in the slide, but for your reference you can remember that as UNO, not United Nations organizations. I'm sure you remember that. That's why I have kept this easy shortcut for you. Now, what did they say in Manipal Academy of Higher Education case? The basic principle is laid down in Bridge and Roof case on a combined reading of section 2b and 6 are as follows. Number 1, where the wage is universally, necessarily and ordinarily paid to all across the board, such emoluments are basic wages, and where the payment is available to be specially paid to those who avail of the opportunity is not basic wages. By way of example, it was held that overtime allowance, though it is generally in force in all concerns, is not earned by all employees of a concern. It is also earned in accordance with the terms of the contract of employment, but because it was not earned by all employees of a concern, it is excluded for basic wages. And conversely, any payment by way of special incentive or work is not basic wages. Now, they have tried to clarify in this judgment also. Let's understand what is universally, ordinarily and necessarily. Universally means everybody, all employee of the organization achieve or all employee of the organization has some component as salary, that is universal. Then ordinarily it is paid without any special performance. Regularly for ordinary performance everybody is getting that, and necessarily paid to the peaceful living of life, or that is part of salary. So those needs to be considered under basic wages. That was the judgment held under Manipal Academy also. It was furtherance to the Bridge and Roof case. There is one more case, Muir Mill Company Limited versus the Workman. Here the basic wages never includes the additional emoluments which some workmen may earn on the basis of a system of bonuses related to the production. One thing you need to observe in all the judgment, that whatever is achieved by additional effort, for example, you are earning the production incentive. How are you earning? By producing more than the target, you are earning it. Or you are earning overtime. How are you earning it? By staying extra in the organization and working, you are earning it. It is not common. It is not regular. It is only for those people who have did it. That's why these things are not covered under the basic wages. That part was very clear in all the judgment. But the covered part, like basic wages, whenever they try to say, they never try to bring any scientific structure to this, which concluded in this judgment also. I will comment on that at the last part of the video. But now let's understand the 5 cases. This slide you can skip. I am just reading out the 5 cases that have come. West Bengal versus Vivekananda Vidya Mandir. This was 2011 case. Surya Roshni Limited versus Employees Provident case of 2013. Uflex Limited versus Employees Provident Fund and others, 2013. Montage Enterprises versus Employee Provident Fund and another, 2013. And the management of St. Gobain Glass India Limited versus the Regional Provident Fund Commissioner. Now it is more than employer and employee. this tussle is between the PF authorities and the organization. Now PF authorities, whenever they visit for the audit, they would define what is the basic wages. Sorry for that inconvenience. Yeah, every PF authority would like to see the definition in different way, and they have interpreted in different ways, and all these cases came to Supreme Court, and Supreme Court thought these are all in a similar line, so they need to be discussed under one judgment. That's how they all combined and discussed for almost 6 to 8 years. I say 6 because the last case came in the year 2013, and there is 2019 reference also, but however those were discussed in lengthy and then they are being added. Now one good thing that Supreme Court has done is trying bring all those cases under a single roof, and that was the biggest opportunity Supreme Court created to itself to have a landmark judgment under these 5 cases. Have they did it? My opinion I'll share in the last slide. Your opinion is open because every judgment can be interpreted by each individual in a different way. Let's not focus too much on that. Let's try understand what happened in these 5 cases individually. I'm not going into detail, but as for the judgment, whatever they have given, I'll try give the glimpse to you so that you know the background of each cases. Now the first case, West Bengal versus Vivekananda Vidya Mandir and others. This was an unaided school, and they were paying some special allowance by way of incentive to teaching staff and non-teaching staff pursuant an agreement between the staff and management. So they were paying the PF, but they were not paying the PF on special allowances, which was called special incentive, which was an arrangement between management and staff, and it was not covered under the definition of basic wages for this company. That was the first case. Surya Roshni Limited, the case was the company was paying basic wage plus VDA plus HRA plus travel allowance plus canteen allowance plus lunch incentive. PF was not contributed on special allowance. PF authorities held that only washing allowances was to be excluded from the basic wages. Now, if you know the definition of ESI Act, the gross salary there includes all the emoluments paid, including overtime, but not washing allowance. Here in Surya Roshni Limited, of course, overtime is not spoken because it has been already excluded by PF Act, but the PF authority tried to bring the same definition except that point, saying that washing allowances is the only exclusion available for PF basic also. PF basic also. That's case number 2, Surya Roshni Limited case. Now let's move to the third case, which is Uflex Limited versus Employees Provident Fund and others. Company was not deducting PF contribution on HRA, special allowance, management allowance and conveyance allowance by excluding it from basic wages. The authority held that the allowance has to be taken into account as basic wages for contribution. Again, the authority. See, it is all because of authority that is happening. PF authorities, as and when they visit, I understand to an extent why they are getting irritated, because we have a lot of fancy allowances in our salary, and in times organizations also try to misuse by putting too many allowances and keeping very low basic for the purpose of statutes. Now when you try to keep very little basic plus DA for the purpose of avoiding too much burden on PF or your gratuity or bonus whatsoever, which are connected with the basic plus DA under different acts definition, you tried coming up with different fancy allowances. When I say you, I am also involved in that. I am also a HR professional. So we all try to bring a lot of contents in salary slip, like the special allowance, management allowance, conveyance allowance, telephone allowance, computer allowance, traveling allowance, transportation allowance, commutation allowance, city compensatory allowance, you name it, we have it. So we have tried bringing a lot of components, and the PF authorities, as and when they visit, they get it by seeing so much of allowances and very small basic plus DA. And in times maybe they are also genuine, thinking that the PF, ESI and Gratuity Act or Social Security Act should be in favor of employees, and they might be feeling that these are not being justified. So that might be the background for them. But on the other hand, employers feel that PF authorities are always trying to bully on the components of the salary. I am not arguing on that part. Let's move on to the case number 4. Everywhere I make my opinion and say I will not argue too much on that part. Yeah, you can see that in whatever way you want, but I am trying to give as much as information through those comments. Now, serial number 4 says Montage Enterprises Private Limited versus Employee Provident Fund to another. The company was not deducting PF contribution on HRA, special allowance, management allowance, and conveyance allowance by excluding it from basic wage. The authority held that special allowance formed part of basic wages and was liable for PF contribution. Similar with the case number 4. The 5th one was the management of St. Gobain case. The Regional Provident Fund Commissioner, Employers Provident Fund Organization. In this case, the question involved whether conveyance allowance, education allowance, food concession, medical allowance, special holidays, night shift incentive, and city compensatory allowance constitute part of basic wages or not. I think there is nothing more that you can add in any pay slip. There is so many components in St. Gobain's pay structure, and it was being asked whether these can be excluded from the definition of basic wages. These were the 5 cases are being discussed in this Supreme Court judgment, and these are the part I have directly brought from the judgment copy itself. It's just 21 pages judgment, you can read through. I am quite upset that such a big judgment came in just 21 pages, but yeah, in a way it helps us. We can quickly read through and understand whatever way we understand. Take it copy that is available on Google. The Supreme Court judgment copy is available. You can read through. And this one judgment, what does it say? It is therefore not possible to ascertain whether extra amounts paid to the workman were in fact paid for the extra work which had exceeded the normal output prescribed for the workman. So what they say, whatever workman is earning, there is no clarity that it is being earned by workman with extra effort. It looks like it is a normal salary component and earned by every employee of the company. The wage structure and the components of salary have been examined on fact both by authority and the appellant authority under the Act, who have arrived at a factual conclusion that the allowance in question were essentially a part of the basic wages, component a part of an allowance, so as to avoid deduction and contribution accordingly to the provident fund account of the employees. It is not indirect statement, it is direct statement that you guys are playing with different components by naming it in a different ways, just trying to avoid the PF contribution to those allowances. So don't do that. That's the communication they are trying to give here. They said that it is concluded like allowances in questions were certainly a part of basic wages. They are all part of basic wages, but you have named it differently. That's what told here. There is no occasion for us to interfere with the concurrent conclusions of facts. The appeals by the establishments therefore merit no interference. Conversely, for the same reason, the appeal preferred by the Regional Provident Fund Commissioner deserves to be allowed. So, guys, you are going to have tough time. That last line which reads, for the same reason, the appeal preferred by the Regional Provident Fund Commissioner deserves to be allowed. Now, every PF authority will come and give a definition to you. What is basic wages under PF Act? Be ready. I will give those items which we have named under salary. If it is again universally, ordinarily and necessarily paid, then you need to bring them under PF umbrella. So, not wasting too much of time, what does it mean? If any wages paid universally, ordinarily, necessarily under below headings like basic plus DA plus retaining allowance, of course it is being covered in the Act itself in section 2 and section 2B and section 6. The other allowances, guys, remember the fundamental universally, ordinarily and necessarily, because this is going to play hell lot of important role in future whenever we start interpreting that I am giving so and so allowance only to 80% of my permanent employee and 20% are not being paid this allowance. Now it is not universally paid, so I am not applicable to PF Act PF basic wages as far as this component is concerned. Such arguments will definitely come. So remember, the funda is starting with universally, ordinarily and necessarily. The basic plus DA plus retaining allowance, there is no argument. This is covered by the act. Then the other allowances, special allowances, canteen, food, transportation, conveyance, travel, commuting, all these allowances should be covered under basic wages if it is universally, ordinarily, necessarily paid. Then the wage during personal leave, company holiday, maternity leave, this has been covered by the act itself. Then the city compensatory allowance, you name it, PF authority will say we cut it. That's going to be the result of this judgment. You name whatever way you want, except for those exceptions given in the section 2, basically number 3, which clearly says on HRA, overtime, bonus, or gift made by the employer, commission, all those stuffs. Definitely they will not argue on that because the act itself says those are exception. But your fancy names on the salary register, payroll, guys, you name it, PF authority will say we cut PF on that. That will be the meaning of this judgment. Now moving on, what you can do? The first thing is revisit your salary structure. I'm little happy because this judgment came in the end of February. We are in the month of March. This is the time we revise our salaries. So in a way, we got a very good timeline for this implementation of this judgment to see the opportunity to be beneficial for the employees as well as employer. Now, this is beneficial for employees in a way and not beneficial for employees in a way. For example, if an employee is getting 10,000 rupees basic plus 5,000 rupees other allowance, and if it is paid universally, necessarily and ordinarily, then what happens, his current contribution for 10,000 rupees is 1,200 rupees, and when you bring the new definition, the other allowances will be covered, so you have to cover till 15,000, which makes his contribution 1,800. And you also need to, as an employer, you have to, or I don't know whether employee is watching this or employer is watching. I am not giving that context. I am just trying to give a context where both will end paying extra 600 rupees as contribution. Now, is it a happy scenario for employee? I am not sure, because there are people who are just focused on take home salary. Today people are looking at CTC. Now the moment it is 600 rupees added from the employer contribution, it goes to the CTC, and employer will definitely say, guy, see, when I am revising your salary this year from last year CTC to this year CTC, this additional cost coming here, I don't mind where is it coming, but my CTC increases this. So employee will end up losing his take home salary. So I'm not sure. There might be few employees who are interested in saving, they might feel happy, but finally it is burden or benefit. Every individual has different perception, so it depends on each individuals. So as an organization, if you want to not to burden your employee with a lot of salary cut, and you don't want to take additional contribution of 600 rupees in my example, whatsoever the additional contribution is coming to you, then what you can do is have basic plus DA and retaining allowance as is. Bring HRA concept if you are not having. Now, how much of HRA you can have? Cities like Bangalore, if you have 10,000 rupees basic, you can have 5,000 rupees of HRA. This is not a standard, but up to 50% of basic we can have HRA. There is no clear definition on this. Hope someday it will also come, because now people will jump into HRA and put everything in HRA and say this is not applicable under PF, and a PF authority come and see, okay, 5,000 rupees basic and 10,000 rupees HRA for some very small place in some corner of India, and say why so much of HRA is required here. But yes, we take opportunity, and I don't eliminate the chances of too much of HRA component in salary, but don't do that. Try be genuine on this aspect. Now, in a hurry of making it like the entire basic is covered, I'll bring what I'll do is I'll put other allowance also basic. Don't do that, because definition for basic wages for PF is different, for gratuity is different, for bonus is different. So every act says different definition. For example, leave encashment for Factories Act, the states are having payment on basic wages. So now if you are increasing basic wages, your burden will increase every act. So be little wise, take a consultant opinion how exactly to structure your salary. If you don't understand my video, I am giving a clear message, but then if you cannot understand, take a consultant opinion on restructuring your salary. Now, second one, be attentive while changing basic plus DA, as they increase the burden on gratuity and might impact bonus too, as bonus is always discussed along with the basic wages. I have not mentioned payment of wages for the earned leaves and other stuffs. So be wise when you are changing. Don't increase basic to extreme, because this might increase your cost to the company. Now the third one is, this definition change is only for this law. Guys, remember, the basic wages definition discussed here is applicable only for the Provident Fund Act, not to any other act which are in line, similar line. So please remember that. Number 4, if you have an union, discuss with them before progressing. Now don't go in hurry. If you have a union, you will be having settlement. Whenever you are changing the components of the settlement, you need to have a discussion with union, have a clear discussion with union, and then change the components as required. Now 5 is while, okay, spelling mistake there. While this looks for the beneficial for the employees, one need to understand the real voice of employees. Do they need more take home or social security? Now there will be employees who need more take home, and there are employees who need more social security. Social security, when I use that term, you need to remember there are 3 major Social Security Act: Provident Fund, ESI, and gratuity. Provident Fund, to ensure that when you are leaving the organization, if you don't have job for 2 months, there should be some fund that should help you continue your life. So after 60 days you can apply for the Provident Fund, and you can take the Provident Fund amount. Anyhow, EPS amount will be there with the EPS scheme, and when you are retiring, you can claim that as a pension. Now ESI, to the extent of 21,000 rupees gross, you are covered under ESIC Act, to ensure that you and your family is covered under medical benefit, and whenever you don't come on job, couldn't able to attend the job due to health ailments, you'll get coverage including the wages under this act. That is ESIC, how they are protecting. And gratuity, when you work more than 5 years or when you retire, you will get a certain amount on the basic plus DA. That's a calculation. I'll try cover gratuity in a separate session. So that is how they are securing you in different ways. So this is also social security. When contribution increases, definitely it is good for the future, but are they focused on take home or security? That needs to be answered. Then number 6, burden on employer and sustainability of business. If you're directly increasing your cost, you need to see how the business pattern is, and can business sustain with this additional cost. That needs to be understood. And 7th one, if basic is already above INR 15,000 rupees, no need to do anything. Remember that if your basic wage, if your employee basic wage is already 15,000, for example 25,000 basic he has, and other allowances 13,000, and his gross is some 60,000 or so, you need not to do anything, because if you are already covering on basic, maybe you have limited up to the extent of 15,000 or full basic whatsoever, or he is an excluded employee, the status continues same. There will be no changes on that part. Now when you are hiring new employee, this is one interesting point that I am seeing. All these years when we were recruiting new employees, if his basic wage is 14,000 rupees and other allowances are 5 and HRA some 6,000, overall his salary is overall if his salary whatsoever, we would cover that employee because his basic was less than 15,000 rupees. Now this act gives a different definition for basic wages, which includes other allowances and other parts also. If it is universally, ordinarily, and necessarily paid, then he is earning more than 15,000 rupees, he can be directly excluded from the PF Act. That opportunity is there, but try understand how that impacts on your recruitment methodology. That is very important to see. Now my opinion, I'm not sure whether it is important or not, but everybody gives their interpretation, so I will give mine. Take it or leave it, that's up to you. For me, on a serious note, this was one of the golden opportunity that Supreme Court got. 5 cases, and we have very good reference cases like Bridge and Roof case, Manipal case, and Muir Mill case. We had references, good reference case also. And then we have discussed it for quite a long time. And the expectation from Supreme Court was some scientific answers, but this is not giving that clarity. So that's the one upset I have, that the golden opportunity has been missed by not giving a scientific definition on this part. Now we need to wait before we implement, except for the part that I suggested, that restructuring of your wages during April, that you can still consider, because we are not sure from when this will be implemented. Now, is it backdated, or are we implementing from 28 February 2019, or we don't know the timeline, and I am not sure when are we going to get clarity on this timeline, because now that the election in India is coming, maybe there will be writ petitions, then I'm sure definitely the bill might go to the parliament also, and the government interference may be required in this case. So considering all those stuff, we might be in confusion for some time. So only risk that we can reduce is by restructuring the salary from April and trying go with the new definition. Now we need to wait to understand the different interpretations. That is one thing we need to wait for, because senior people will definitely give interpretation, and then we can try understand between the lines that what exactly or how exactly we have to look at this new judgment. And to understand the timeline, as I said, we are not sure, is it backdated or from today or from so and so date. It's not very clear. Of course, it is not later than 28 February 2019. That's so sure, because the judgment has already been given. Then the last part, to see the challenge against this judgment, there might be challenges coming in, because the bonus judgment came in year 2014-15. It is been challenged and still in Supreme Court, not clarified completely. So that's my take. Hope you have got some clarity after seeing this. If you have not got clarity, that is not my mistake. Whatever has been given in the judgment, I tried give it in a very simplest way possible, and whatever you are not being clarified, I am also not clarified with this judgment. So with that, I am concluding this session. Thank you so much for watching this session. Please like, share, comment on this video, and subscribe my channel for more videos and legal series videos from my classes. Thank you so much. You guys have a good day, and hope we get some clarity in future, and I might come up with a new presentation on this to give more clarity to you guys also. Till then, have a good time.